Good morning, everyone, and very welcome to this CDH Retail Sector webinar. We really appreciate you taking the time to join us this morning, especially given the events of the past week that affects all businesses, but especially our clients in the retail sector. And we are acutely aware of it, and makes our appreciation so much greater for you joining us this morning. The CDH embarked on a sector-based approach about 2 years ago, and the purpose of it really is to bring together experts within the firm that's got intimate knowledge of the sectors our clients operate in. And this, of course, the retail sector, and it's obviously specifically focused on our retail clients. And you know, we do have a whole raft of people that have a lot of experience in the sector. And this is different to our internal areas of specialization. So it's kind of like multi-skilled teams that we apply or deploy on various matters. So this morning, my name is Christoff Pienaar, and I'm the National Practice Head for Technology, the Technology, Media and Telecommunications Practice. And I will be joined by the sector head of our Technology and Communications Sector, Director Preeta Bhagattjee. And we will give you an overview of the recently effected Protection of Personal Information Act, and of course the compliance deadline that expired the 30th of June. So the 1st of July was kind of like D-Day. So we'll start just with the, I'll just quickly run through the agenda. And while I'm waiting for that slide, questions and answers can be, or questions can be posted using the Q&A button on the Teams application throughout the talk. As we want to keep this brief, we will only have, let's say, 10 minutes or so at the end to deal with Q&A. And for that reason, I will moderate the questions, and I will deal with, let's say, the most asked ones. And that is just to keep within the time, and you know, everyone has got busy schedules and things to get to. So we're going to start with an overview of the Act and just put it into context. Then Preeta is going to talk to us about current and ongoing compliance requirements. Then we're going to focus on 3 specific areas affecting the retail sector, or that's very topical to the retail sector: loyalty programs, e-commerce, and then of course direct marketing. And then we will allow 10 minutes or so at the end for questions and answers. So just as an overview, and to put this into context, in Europe in '94, the European Commission published a directive, the EC Directive 94, in which they compelled all member states of the European Union to promulgate in-country data protection legislation, and the result of that was the UK Data Protection Act, or the German one, etc., etc. And then for a good few years, you had all those issues on this topic like safe harbor, data transfers from the EU to the US. And then in 2018, the General Data Protection Regulation, as known as the GDPR, came into force. And the difference between a regulation and a directive in Europe is that a regulation applies to all member states as if law, where a directive directs you to pass local legislation. But under the GDPR, European Union members also have the option to promulgate local legislation as long as it's aligned with the GDPR, and an example of that would be the 2018 UK Data Protection Act. Now, since the mid 1990s, there's been this move to recognize, people's right to privacy when in their kind of commercial dealings and their day-to-day dealings with organizations. And this is really where this fits in. But on another level, it's becoming good, having good data protection practices, either as an organization, well, firstly as a country, but secondly as an organization, has to some degree become a bit of a passport to do business across borders, especially with Europe and the United States. So there is on the one hand, you have this right to privacy, and you have this let's call it like compliance obligation, which can be annoying at best. But then there's the positive side to it that actually says, well, it makes good business sense. And there is an incentive to, let's call it, be a safe harbor for data, one as an organization, but also, and well, most importantly, as a country. So that is just to give some context to where this new piece of legislation, or, well, it's not a new piece of legislation, but where POPIA fits in. All data protection legislation are broadly based on 8, I know some legislation had broken it down to 9 principles. And these are indicated on the slide. And I won't go into too much detail each one of them, but if we could start with something like processing limitation, it's common across data protection laws to contain a provision that says that you can only process personal information or personal data, as necessary, and you should do it in a minimalist way. Only for the purpose, brings me to the next one, purpose specification. Your organization has to take reasonable and appropriate technical and organizational measures to safeguard data. There needs to be accountability, and a good example of that would be, and Preeta will touch on this more later, but it's the appointment of an information officer. And then, of course, data subject participation, because the data subject will have a say in all of this. So, for example, a data subject can, one, request that data be corrected and updated if outdated or incorrect. They can complain to the regulator that their rights have been infringed under the Act. And they can also request data to be deleted. Now, having said that, that obviously must be seen within the framework of current law. So you have various pieces of legislation in South Africa that requires retention. So those will trump. But there are those participation rights, and then of course trans-border data flows to make sure that data is not transferred to countries or to organizations that do not offer comparable protection to personal information. Then information quality speaks to the accuracy and the completeness of information. And then, of course, things like information security, etc. And it affects literally the entire, let's call it, supply chain. Both service providers, customers, parent company, subsidiaries, the entire group. In South Africa, POPIA was enacted into law in November 2013 on the 26th, and the President declared the commencement date as the 1st of July 2020, and there was a grace period included of 12 months to become fully compliant, and that recently expired on the 30th of June. And effectively, that means that from 1 July, one is considered compliant and enforcement can commence. In the period between 2013 and 2020, was certain parts of the Act was in force, and that purely related to the establishment of the Office of the Information Regulator, and for certain administrative implementations to take place. Broadly speaking, the purpose of the legislation is to regulate the use of personal information generally by business, to ensure that there's a balance between the ability of business to use personal information for its legitimate business purposes, and on the other hand, the data subject's right to privacy. So it's very much a piece of, like, there's a balancing theme throughout the legislation. And then a peculiarity that slipped into the South African Act is that it applies to personal information of both natural and juristic persons. Now, the jury is still out on exactly how it would apply to juristic persons, because a lot of juristic person information are public record at, sub-C and publication of financial statements, and what is shown on companies' websites, etc., etc. But it does mean that things like restrictions on and procedures prescribed for things like direct marketing and so on would apply to both natural and juristic persons. Who's who in the zoo? The entity or the body that owes the compliance responsibilities referred to in the Act as the responsible party. Broadly speaking, that is the one that decides or determines the collection and the purpose for which information is used. The data subject, of course, is the individual or the juristic person whose data is concerned. Then an operator in European legislation, the Gdpr refers to as a processor. That's essentially a third party, such as a service provider, to a company that deals with or handles or processes personal information for which the responsible party is responsible. For example, a payroll service provider. That's probably the most common example. The information officer, Preeta would speak to that a bit more, but that's essentially the Act requires each legal entity to register the details of an information as well as a deputy information officer with the Office of the Information Regulator, and that person is essentially the point of contact for communication to and fro the regulator. And then right at the bottom of the slide, the information regulator is the regulatory body established in terms of the Act, and essentially has got three functions: to educate, to monitor, and then of course to enforce compliance. What is personal information? I think that doesn't require much explanation, but we have set it out there on the slide. It's essentially anything that can identify a living person, a living natural person, or an existing juristic person, well, a juristic person generally. And then there's this subcategory of special personal information to which a stricter set of consent requirements and processing requirements apply. And these are what one probably can imagine they are, but these are things that can potentially drive discriminatory behavior, and things that are like, let's call it ultra sensitive to individual concerned, like for example their health information and criminal record and race, ethnic origin and the like. And most importantly, the information of children is dealt with separately, but it essentially is more or less treated the same as special personal information. Additional requirements apply to that. Where would you find personal information in your organization? It's everywhere, as you know. We have the various departments or divisions or functions within your business. You have offsite storage. You make use of cloud storage. There are third-party service providers. There are outsourcing service providers. And as I mentioned before, it affects the entire supply chain from the customer right through to suppliers. And just on the concept of processing, there's a very detailed definition in the Act, but I think if one takes away this understanding that processing entail, first of all, the collection, the deletion, the sharing and storage of personal information. I think we can move on to the next slide. I've covered that. I will now hand over to Preeta to take us through the steps to achieving compliance. Thank you, Preeta.
Thanks, Christoff. So, having explored the key principles of POPIA in Christoff's discussion, I want to turn to some of the practicalities of compliance, and especially with the 1 July cutoff date having passed, and in essence the hype having died down, the trick really is to calmly unpack the requirements of the legislation to effectively ensure ongoing compliance. And it's ongoing compliance that works best for your specific business requirements. So what does this mean? Firstly, it is step one, appointing an information officer and really formalizing that appointment. And where required, also addressing the requirements for deputy information officers. Step two then requires a documentation of your current data processing activities. So this is looking at what types of personal information you process in your business and mapping out and recording what you do with that personal information. Against that, step three requires that you assess that processing activities within your business against the requirements of POPI, which Christoff has just outlined to you. So in other words, to what extent does your processing activities already meet the compliance requirements, and where are the gaps? And essentially step four is addressing how best to achieve compliance by bridging those gaps and implementing appropriate compliance measures within your business. And that inter alia could include implementing appropriate procedures, practices, where required, implementing POPI compliant consents into your various business processes, be it either internal vis-a-vis your employees or external vis-a-vis customers or suppliers. And then arguably the most important step, which is step 5, is having and implementing an effective system to both manage and maintain your compliance with the requirements of POPI on an ongoing basis. So what does an effective ongoing POPI compliance management system look like? Well, it's going to depend on the kinds of activities that your business, or the complexity of data processing activities that occurs within your business. So it could range from quite a simple system of managing compliance to some businesses having a more complex and electronic-based system to achieve and maintain compliance. But if we unpack what are the key requirements of that system, it is simply this, is once you have done the hard work, and many of you on this webinar are likely to be well underway, or if not close to achieving a stable compliance environment, with POPI having come into effect and enforcement having come in, or been put into place from 2 weeks ago. But what the system would do going forward is really help you keep track of changes in your data processing activity and effectively do that. So your system would need to alert you of changes as well as new and increased risks. And the same system should allow you to easily address these changes and risks in both a time and cost efficient manner. And a few more words on what that compliance system should look like. Important to understand the framework and the basis of data protection laws. The same model applies for the majority of legislation across the globe, and POPI is no exception. The same basis applies, and Christoff has mentioned that our laws emulate the EU models to a large extent, and that is that data protection laws are principle-based. So what they do is they tell you what the rules are, what the principles are against which you can use personal information. They don't necessarily tell you the how. So that requires you to adopt a risk-based approach. So this is actually enshrined in the history of data protection legislation. So it's in the Gdpr, which takes a flexible risk-based approach and really puts the onus on you to manage your use of personal information in line with those principles. But it goes further back, and the OECD guidelines, in fact, some time back already specifically stated that in order to manage compliance, you must implement a risk-based approach. And so just to clarify, applying a risk-based or risk management approach doesn't mean that you effectively alter your rights or obligations under the legislation. It just means that you implement an appropriate tool or framework in order to manage your compliance against actual risk and then prioritize compliance against that framework. So if we move on and unpacking how the nuts and bolts of a compliance program would look, we start again at the information officer role, and it all really flows from this. And of course, many of you would have followed eagerly the debates in the recent weeks in regard to the registration of information officers, and I'll come to that in a moment. So who are information officers? They are in effect individuals who de facto under the law, so in terms of POPI, read with the Promotion of Access to Information Act, the PIA legislation, they are de facto the CEO or the equivalent in respect of a private organization. So it's effectively someone that's delegated or assigned this responsibility under the law. However, that role can be delegated. And in addition, under POPI, it allows for the designation of one or more deputy information officers. So the information officer may then delegate components or all of the compliance obligations under the legislation to these deputy information officers. The one key requirement is this registration of the information officer and the deputies, if you've elected to appoint these, with the regulator. So the regulator has established an online portal on which you can register your information officer and deputies. And if you had got in quite early a few weeks ago, then lucky you would already have completed the registration process. However, for the last while and up to this morning, the notice that's on the slide comes from the regulator's website. Their portal has been down, so for now it isn't possible to actually complete the registration. However, the regulator has stated that there is no longer a deadline in respect of this registration, and we'll wait to see when that portal is available again. But I do want to note in respect of the appointment of, or rather the role of the information officer. So whether you delegate the information officer role from the effective, the CEO or effective head of a business to someone or not, in the next few slides, I'll unpack all the requirements under the legislation, which talks to a fair amount of work, even though you would have done a fair amount of hard lifting initially in reaching a reasonable level of compliance. There is a reasonable amount of work going forward, and hence this effective management system. But tied to that, we generally are of the view that it is preferable to have a so-called privacy office or information office. So basically a function that assists the information officers and deputies to fulfill their role, and that could be peopled with whoever is required to make sure that compliance runs as smoothly as possible. So let's unpack that a little further. So some of the key requirements of an information officer, and what we suggest is managed in some form of centralized or organized privacy office, is the responsibility of overall management of compliance, and this is both with POPI and PIA. And in terms of PIA, many of you would already know and have a PIA manual in place, and this is specifically in terms of a requirement under PIA. Then under POPI, you need a compliance framework which sets out how you approach compliance with POPI. POPI also requires that you document the data processing activities taking place in your business. It also requires you to carry out what's called personal information impact assessments. So this was really one of the steps that I discussed in the first slide I spoke to, but this is an ongoing obligation in the sense that as and when there are these changes or new processing activities within your business, it would be prudent to perform an impact assessment, basically checking that either the change or the new processing activity is done so in compliance with the requirements of the legislation. Okay. Then further, a specific obligation of the information officer, and one of the reasons for the requirement to formally register your information officers with the regulator is that the information officer must be available to the regulator to contact in the context of conducting investigations relating to compliance issues, or where there are information requests. So how this could manifest is that a data subject could lodge a complaint against you with the regulator. The regulator would then investigate that. You may experience a data breach, and as a result, the regulator requires to carry out an investigation or requires more information. Or it may just occur in the context of a general audit by the regulator into your compliance activities. Then a further role of the information officer is to address data subject access requests. So these tie in with PIA requests, but under POPI, there are specific rights that a data subject has to request access to the personal information you hold about them, to request correction of that information, and also under certain circumstances to request the deletion of personal information that you have on record about them. Tied to that, the legislation requires an internal access procedure. So basically a process that would get followed internally in order for you to handle and address these data subject access requests. Further, there's a requirement that the information officer manages and oversees transfers of personal information. So this would relate to information going in and out, and more so out of your organization, and managing the compliance risks relating to that. And it would also apply to cross-border data transfers. So any information leaving South Africa, in that case, particularly the requirements of Section 72 of the legislation would need to be addressed. Right, and then another key requirement is that of training and awareness within your organization. So this is an obligation, again, on the information officer to raise awareness and ensure that staff are effectively appraised of ensuring that the business maintains compliance with the legislation. All right, then just a little bit further, a few more points on how to effectively manage compliance. You would no doubt have heard a lot and probably done a lot of work around POPI compliant policies and procedures to ensure that you achieve compliance. Privacy policies and the like are required. And then there are also agreements that are required, particularly where third parties are involved in processing your information, but it also could be that you process information on behalf of a third party. And again, in this space, often in the context of modern business practices, data is often shared or transferred and used between different businesses. So it could be within a group, or it could be with third parties. And in those cases, appropriate agreements and compliance requirements are key to be assessed. Okay, then another requirement is to put in place appropriate retention procedures. So many businesses already have general retention or record retention policies or procedures, but POPIA's changed this. It's brought in a different angle, so to speak. So by that I mean that all of you would know that pre-POPIA, there are a number of pieces of legislation that require you to keep personal information for certain prescribed time periods, so the statutory retention period. And the purpose of that was to ensure that you don't destroy information before that retention period has expired. POPIA comes at almost a different perspective, and that is that you must not keep records for longer than is necessary. So it is taking those retention requirements a step further and requiring you to not just keep for a minimum period, but to not keep it for any longer. So disposal processes in compliance with the POPIA requirements is something that is quite important to get your head around. And with POPIA compliant retention policies and procedures, it's as important to get the framework and the policy right as it is to actually operationalize compliance. So whether that's by implementing appropriate IT systems to manage the retention and disposal process, or just operationalizing it with ensuring staff follow these procedures. This is something that arguably is causing many of our clients headaches in addressing past practices and regularizing the new practices in compliance with POPIA. Okay, and then around consent management. So you can just go back. So consent management. So however you do it, you need to have a system to keep track of consents, POPIA consents that you're collecting. And this is so that you can prove and demonstrate that consent, where you're relying on consent as the basis on which you're processing information, then you need to be able to track and manage that consent. And that also includes managing where consents are either refused or where they have been withdrawn. So it might sit in various areas or various different departments in your business, but from a central privacy office perspective, it's important to have a view of where that information is and an effective management or tracking system in that regard. Okay, then on to data breach response procedures. So this is advisable to have in place because it's definitely advisable to be prepared for any kind of data breach that your business may experience. You can move on to the next slide, please. Thank you. And so you would already have fairly robust systems in place to deal with IT incidents and cyber incidents. But from the perspective of overall compliance and overall risk management, the information officer should really ensure that in planning and preparing for these eventualities, that adequate breach detection, investigation, and internal reporting procedures are in place. And this is so that when you do have an incident, that there is an orderly and organized process that's followed to detect and analyze the data breach, analyze what data and personal information in particular has been affected, consider contractual and legal implications of your data breach, and also to ensure that you have effective internal reporting in terms of predefined escalation procedures. So in other words, to ensure that you don't have panic and pandemonium, and everyone maintains cool heads in the situation. And then importantly, from a POPI requirement perspective, is that there are specific notification obligations under POPI, notification to the regulator as well as to affected data subjects. And depending on the nature of the breach, so for example, if it were to amount to a cybercrime, you may have additional notification obligations, such as under the Cybercrimes Act, or in terms of general criminal requirements. Okay, moving on. A further obligation in terms of the ongoing compliance paradigm is ensuring information quality is maintained. So this is one of the key principles or obligations under the legislation. And again, what does this mean? The legislation says you must take reasonably practicable steps to ensure that information is complete, accurate, not misleading, and updated, emphasis where necessary. So it's important to identify the categories of personal information that you need to keep updated, and then implement a procedure to do so on a regular basis. Whatever that regular basis is would depend on the type of information, and then the how is you would need to build into preferably your current processes an update requirement. So, for example, every time a call comes through to your call center, or where you have reapplication processes, that step is built in. But again, important to ensure that an effective system to manage and track that is put in place. Okay. Then just to remind you, another obligation is that of data subject access, or rather data subject notification, or the transparency requirement. So the information on the slide indicates specifically what information must be made transparent to data subjects when you process their information. And generally, you will find this in, or will include it in, your overall privacy policy or in specific privacy notices. The reason I raise it as an important checklist item in terms of ongoing compliance is that as and when changes in your processing activities take place, you must remember to make sure that either privacy policies are updated or appropriate privacy notices are issued for that particular new or change processing activity. Okay. All right, then to speak very quickly on how to deal with third parties processing personal information, and we get this fairly often in terms of the question of what is the role of the various third parties that interact with our data, or that we interact with others' data, and what are the risks and obligations? So if you could press the slide forward, and again, thank you. What's on the slide is the difference between a responsible party and operator under the legislation. So Christoff did discuss this earlier, and essentially what you would need to do is, in determining how information is coming in and out of your organization, is to determine the category to which each of the third parties fall into. Are they a responsible party? In some cases, they may be a joint responsible party with you, or are they an operator? And an easy example of that is where you've outsourced a data processing activity to a third party, such as a payroll processing activity, and they specifically process information on your instruction. Appropriate agreements and or risk-based assessments of compliance are required in regard to these relationships. I think I just want to say that there is a lot of confusion between when someone is an operator and when they're a responsible party. It is very much dependent on the specific facts and the nature of the data processing activities. But moving on from there, I also want to alert you to the requirements of Section 19, which again, a key principle is that you have to have appropriate security safeguards in place. And this obligation takes that further in that it requires you to, on an ongoing basis, look at those safeguards and verify that they're still appropriate. So it may no longer be the case because of changes in your business, or changes in the nature of your processing activities, or because of external risks or threats. And as a result, you may need to amend and beef up your safeguards. So this is a requirement to build into your ongoing compliance management program, and to definitely record, minute, and record any risks and track implementation of changes in this regard. Okay, then the last point on ongoing compliance is the concept of privacy by design, which again is something that many of you would have heard a lot about, and that is how to manage going forward, and in the context of having a framework like POPIA to comply with, how do you manage changes to your business? And the privacy by design principles essentially require, and they're effectively built into POPIA, is they require that as you have changes in your business, so you have a new line of processing activity, or you do something different, or the type of information is changed that you're processing, you would need to, at that point in time, assess the compliance requirement under POPIA. And instead of having a scenario where you implement something into your business and then realize that there are data protection implications, the privacy by design process, and really the obligations flowing from POPIA, require that you assess the risk and implement an appropriate compliant change in your business. And examples of this include a new mobile app that you may launch, or outsourcing a business function, or launching a particular marketing or advertising campaign, or even an information sharing arrangement that is different to what you may have carried out in terms of information sharing in the past. Okay, so now I will hand back to you, Christoff, to take us through the beginning of our last section.
Thank you, Preeta. This part deals with retail-specific POPIA considerations, and the first one that I just want to touch on is loyalty and rewards programs. Now, from experience, I know that a lot of retailers who do offer loyalty and rewards programs, because of the accounting treatment of loyalty points or reward points, it's often housed in a different company within the group that then manage these rewards programs and essentially keep these outstanding due rewards as contingent liabilities. And the point I just want to make in that regard is that the Act applies to each individual legal entity. So it would be incorrect to view like the group as one insofar as compliance is concerned. So, for example, if Company A, who runs the loyalty and reward program, collects all this personal information for purposes of this and then share that information with Company B, both being group companies, care should just be taken, and what we commonly do in practice is we make sure that there are intra-group processing and sharing arrangements in place that are documented among group companies. And I will now, Preeta will take us through e-commerce and the online retail world, as well as just say something about direct marketing, and then I will do some closing remarks and Q&A. Thank you, Preeta.
Great, thanks. So with the advent of the digital economy, e-commerce and online interactions and opportunities in that space are clearly a hot topic in the retail sector, and it's fairly self-evident that the COVID pandemic has also resulted in an increase in online activity, e-commerce, and also there are a number of studies that show how smaller businesses have effectively used online retail platforms, online marketplaces to build and grow their business. So in this space, from a data protection perspective, it is quite important to look at not just the front-end online journey with a consumer, a potential consumer, and an actual consumer, but also to look at the information sharing and processing in the back end. And so if we start with that online journey of consumers, there is a piece that relates to having the ability to access and gain information about either website or app users. So this is the space of the use of cookies and web-based analytics tools, as well as the opportunities you have in an online journey to interface with the customer, to allow them to subscribe to newsletters, to get them to sign up to receive marketing material from your business, and also then to take them through an online sales process. In each of these different permutations of interactions, and it may also in more complex arrangements relate to different businesses or all in one, so either via marketplace or where a group of companies' products are consolidated and sold either on a B2C or B2B basis, but through a common portal. All of those require consideration as to when you do get access to any personal information, whether you're compliant with the requirements of POPIA. So in other words, at each stage, you need to test whether you have a lawful basis to have and receive that information and do with it what you're intending to do with it. And in some cases, you may be able to rely on a basis other than consent, but in many cases you would need to build POPIA compliant consent into your online process. Of course, there's also the complexity of in the digital economy, there are no borders, but from a data protection perspective, it's important to bear in mind that if your customers are not all in South Africa, you may need to look at compliance with foreign data protection legislation. And then just a word on the back end is you may have payment processors, you may have external service providers who manage your platform, or you may actually choose to host your business in a third-party aggregator or marketplace. And there are various data protection implications there, and in some cases, you are going to potentially have those third parties, and they could even be cloud service providers who are located outside of South Africa. And again, the cross-border requirements of the data protection legislation would need to be considered. And I think we're running out of time, so I'm going to just touch very, very briefly on direct marketing, also quite a hot topic in the context of your businesses within the retail sector. And the trick is to regularize existing practices. I think I saw a question around the sale of lead databases and those practices. So the answer to that is that it's going forward and in compliance with the requirements of POPI. Those sorts of activities need to be very strictly tested against the requirements of the legislation and regularized. So in some cases, it may be possible to continue and proceed, and in other cases not. It will depend on the construct of what the lawful basis is, and what your entitlement to a particular customer database is. And for your own internal database, it would be to look to, again, regularize. So it's a process of, if you haven't done it already, cleaning up the database so that it is a POPI compliant marketing database, and then making sure you have the appropriate marketing-based consents, broadly speaking, in terms of particularly direct marketing activities. And just to mention that the CPA and POPI work hand in hand. POPI requires that whatever marketing activities you do in whatever mean or medium, whether it's face-to-face, telephonic, or via email, SMS, and the like, you still have to have that lawful basis, and you still have to comply with POPI to have that information in the first place. And then the opt-in, opt-out works a little differently between face-to-face and telephonic marketing versus electronic. But I'll leave it there so that we can address some of the questions. Christoff?
Thank you, Preeta. Just on a few closing remarks, and then and I will also deal with about 2 or 3 questions. As a one of the main concerns I think that most businesses have, and this is not particular to the retail sector, is that it's almost, you know, I want to express it as we need to wait and see how this piece of legislation settles within the current legal framework, because, you know, obviously with any piece of new legislation, you always have some teething problems, and it's sometimes difficult to reconcile different, you know, pieces of legislation that might be contradicting. But I can say this, that, you know, there's very little precedent, obviously, in South Africa, but we do look to what European regulators are doing and find it very useful. You know, looking at some of their practices, just because this kind of law has been enforced there for quite some time. And then there was I just want to deal with the question whether contractual parties are able to contractually agree to retain a copy of an agreement for longer than is necessary as per the legislation. And I will. The answer to that is yes. Yes, you can. Because one of the lawful grounds for processing would be the performance of contractual obligations. That just has to be balanced in the background, against the minimal approach that POPIA prescribes. So, for example, two parties can't, for example, say we're going to keep this database for 25 years and send everyone marketing communication. But the answer is yes. And then I have one question for Preeta, and that is what potential personal liability can an information officer assume?
Thanks, Christoff. Yes, so that is also an often asked question, and clearly top of mind for many trying to grapple with the extensive obligations of taking on the role of information officer. And it is a little bit of a nuanced answer, but I will say this broadly. POPIA, as opposed to PIA, in fact, POPIA doesn't specifically talk to the information officer per se being guilty of an offence. And so one must bear that in mind. It talks to the responsible party and it talks to a person, and person under POPIA is defined as either juristic or a natural person. And I believe that just broadly speaking is deliberate because it casts the net wide, and it's, I think, in line with the requirements of the legislation, which is that the onus of compliance ultimately is really on the responsible party, the organization or business itself. Having said that, the consequence of certain types of offences provided for under POPIA, such as obstruction of the regulator and their activities, or preventing a warrant of execution from being effected and the like, it could relate to a specific individual, and therein lies risk. And of course, the penalties are not just administrative fines for offences, but also potential jail time. So that seems to indicate that if it ever came to that the individual who would be the one taking on the orange overall is the information officer. But I think, again, we have to temper that position or that view with two things. One is, unlike other laws, POPIA legislation is not about one strike and then you out. It is a process. So in order to get to the offences, there would have to be quite drastic non-compliance. And so, just to look at it pragmatically, you're unlikely to get there if you're doing what you should, and if there's ever any kind of risk, a complaint, etc., there are appropriate processes to follow. And the other side of it is to look again to Christoff, your point about looking at the EU and the GDPR and its predecessor for guidance. And there's, albeit that the legislation is not identical in this respect, but there's been very, very, very few actual fines or offences placed on individuals. And in fact, there's been no data protection officer that I'm aware of that's gotten jail time. So I think the context is quite important to flavor that. Thanks.
Thank you, Preeta. And I just want to say thank you to each one of you for making the time and for attending. I sincerely hope you found this useful, and just for everyone's notice, a copy of the slides as well as a recording of this webinar will be sent to everyone who is RSVP'd. All the best and have a great day further. Thank you.